Hi, I'm Stephen Bourke, Principal of Supersplitting. What I wanted to talk to you about today was how to deal with some problems in self-managed super. Typically you'll find that in a self-managed superannuation fund, the husband has the greater interest and the wife is the less active of the two trustees. If you're acting for the wife and you're having difficulty in getting access to documents, consider this as a strategy. Remind the accountant that your client is a trustee and failure to disclose the documents directly to your client is interfering with the trustee's ability to discharge the obligations of the trustee. That would leave the accountant liable for any loss that the trust might suffer. In addition to that, you can use the principle of the trustee des tort, which is interfering or intermeddling with the trust. We find that if you advise the accountant of those two principles, that the documents are typically forthcoming pretty quickly. In addition to that, always remember that there is now authority for trustees acting in that way in the Queensland Supreme Court case of Fitzgerald's and the Tax Commissioner. Justice Logan in that case, and I'll read from his judgment, said that it is quite unacceptable for a fellow trustee to be a passive participant in a breach of trust, no matter what the matrimonial pressures might be. That tells us that the wife is equally responsible for the trust and those duties have to be observed strictly. So warn the accountants that you need the documents, and that's a much easier way of obtaining them rather than any court application.